everyone, and welcome to Crime in Court. This is the Canton cover up series, Commonwealth versus Karen Reed, and we are on episode 106, Reciprocity, not a trial by ambush. So, we're going to go over a couple of the latest filings. We're still making our way through them all because there were so many in the last few days, and so we are making our way through them, and it kind of is helpful because now we can read one and we can read what the Commonwealth writes, and then we can read the defense's response, and then the Commonwealth's response to it again. So we're kind of getting like all the same motions in order, which is kind of nice. So, anyways, so we are going to go over the Commonwealth's request. First of all, they are requesting reciprocal discovery from the defense, and the defense is gonna have some things to say about that. So let's get into it. Please hit that like button. Let's get started. All right, so the Commonwealth's motion for reciprocal discovery and notice of any experts. Now comes the Commonwealth in the above titled matter and respectfully moves this honorable court pursuant to Mass R. Crim P 14A3 to order the defendant to produce the following material and information for the Commonwealth to discover, inspect, and copy by March 6th, 2025. The name, home address, and date of birth of any individual whom the defendant intends to call as a witness at trial. Any written or recorded statement, as well as any oral statement reduced to writing of any individual whom the defendant intends to call as a witness at trial, including but not limited to such statements contained in defense investigator reports or other non legal reports. So, even certain statements they want. If they're going to call a witness, they want to know what statements they're going to be using to impeach those witnesses, which is kind of not the point. You kind of want to surprise that witness and confront them with your smoking gun. You don't want the prosecution to prepare those witnesses prior to trial or prior regarding what statements they might be impeached with. So that's kind of an issue. Any written or recorded statement, as well as any oral statement reduced to writing or any individual whom the Commonwealth intends to call as a witness at trial, including but not limited to such statements contained in defense investigator reports or other non legal reports. Again, trying to know what statements you're going to show to a witness. Any promise, reward, or inducement offered to any individual whom the defendant intends to call as a witness at trial, including but not limited to any monetary fee paid or to be paid to a witness. Any and all books, papers, documents, photographs, charts, diagrams, chalks, which are like big visual aids, tangible objects, or other material and relevant evidence that the defendant intends to rely upon or introduce at trial. Any evidence the defendant intends to introduce or rely upon to attempt to impeach the credibility of the Commonwealth potential witnesses. Expert evidence, they want the names, home address, work address, telephone number, date of birth, and curriculum vitae of any individual whom the defendant intends to call as a witness at trial, a complete statement of all opinions to be expressed, and the basis and reasons for each opinion, all notes, reports, raw data, and materials relied upon that form the basis for each expert's opinions. All compensation paid or requested, including case preparation, testimony, travel, and any other compensation requested, even if not paid to date. Any contracts, agreements, or documents discussing compensative relative to this case. A lot of this is like normal discovery that they would have to turn over anyways, I would think. A copy of all testing and results, regardless of whether the witness will testify to that information at trial. Any and all results or reports of physical or mental examinations conducted by any person or of specific tests or experiments, including results or reports of expert witnesses the defendant may call at trial, within the possession, custody, or control of the defendant or persons under his direction and control that are material and relevant to the indictments and that the defendant may use or introduce at trial. That was a long-winded one. This one looks long too. Okay. So, written notice of whether the defendant will rely upon any defense of lack of criminal responsibility due to mental disease or defect, stating whether the defendant intends to offer testimony of expert witnesses on the issue of lack of criminal responsibility due to mental disease or defect. What? This is bizarre. The name, address, the date of birth of any expert witness whom the defendant intends to call at trial, whether any expert witness intends to rely in whole or in part upon statements of the defendant as to her mental condition at the time of the alleged offenses, or as to her criminal responsibility for the alleged offenses. To prevent, if I'm confused by that one. Um, To prevent trial by ambush, the Commonwealth is entitled to reciprocal discovery from the defense by March 6th. Previously, the defendant selectively produced reciprocal discovery in 3 increments, one day before the first trial on April 15th, then during trial on April 28th and May 5th. As the Commonwealth is entitled to a fair trial, all reciprocal discovery shall be ordered to be produced to the Commonwealth by March 6th. This is rich, coming from the Commonwealth wanting certain evidence turned over to them because they have a hard time turning discovery over to the defense, it seems, especially when it comes to the Sallyport video. While the defense is still receiving bits and pieces of Sallyport video with no metadata. And anytime they mention metadata, Hank has a little freak out. So, kind of a bizarre ask when you're not also turning over your requirements. And they have already turned in their certificate of compliance for having completed their discovery obligations, but we are still getting discovery obligations. They just did one yesterday, and there was actually like some transcript from a Turtle Boy hearing that they turned over in discovery. So interesting that that comes in now. But so yeah, they're still getting discovery, even though Hanky's like, I'm whining and complaining that they're not just sending me their discovery. So interesting that. Anyway, so this is the defendant's motion to reconsider reciprocal discovery. And here we go. So now comes the defendant, Karen Reed, and respectfully moves this honorable court to reconsider its reciprocal discovery order regarding the defense pretrial production of impeachment evidence related to the Commonwealth's anticipated trial witnesses. As grounds for this motion, the defendant states that production of impeachment evidence prior to witness testimony is not required under Mass R. Crim P 14A1B and will unduly prejudice the defense by allowing witnesses to tailor their responses to preempt cross examination. So basically, they're saying you guys are potentially prepping the witnesses, preparing them to be able to know what exactly to say on cross examination, and it takes the sail out of the defense's wins when they try to bring it up on cross examination because the Commonwealth already brings it up on direct. So that's kind of it's an issue for the defense here. So, the production of impeachment evidence related to witnesses proffered by an adverse party is not subject to mandatory disclosure. So, so it is not subject to mandatory disclosure under Rule 14. And in this case would be particularly prejudicial to the defendant given the public nature of the proceedings and the close personal relationships of many of the parties involved. Factual background: Ms. Reed is accused of the following crimes arising out of the death of Officer John O'Keefe: homicide in the second degree in violation of Statute 265, count one, manslaughter, also leaving the scene. Ms. Reed faced a trial by jury for the above crimes beginning on April 16th, 2024. Prior to the commencement of the trial, the Commonwealth submitted a motion for reciprocal discovery and notice of any experts, filed on March 21st, 2024, with this court. Paragraph 4 of the Commonwealth's motion requested production from the defendant of any written or recorded statement, as well as any oral statement reduced to writing of any individual whom the Commonwealth intends to call as a witness at trial, including but not limited to such statements contained in defense investigative reports and non-legal reports. So that was also in Brennan's it was also in Brennan's request here, wherever that was. I can't find it here. So it's basically the same language as point two in Brennan's motion now. So he's basically renewing that motion from the first trial. And she ruled in favor of the Commonwealth at that time, and it bit them in the butt a couple times during trials. So she's going to give us a couple examples of that. So the Commonwealth, I believe this is Liza Little who wrote this, but I'm not sure. Um, but anyways, so the Commonwealth's motion was allowed by this court, requiring the defendant to turn over evidence intended to be used as impeachment evidence against witnesses called by the Commonwealth prior to those witnesses being called to testify at trial. On several occasions, during various Commonwealth witnesses' testimony at trial, the witnesses subsequently tailored their testimony and included details which had not previously been discussed to account for the impeachment evidence turned over by the defense. So, in other words, the Commonwealth was trying to get ahead of it instead of allowing the defense to be able to impeach them on the stand. For example, at trial on May 21st, 2024, Jennifer McCabe testified for the prosecution. During cross-examination, Ms. McCabe testified that on January 30th, 2022, the day after John O'Keefe had been found in front of 34 Fairview Road, she went to the house of Canton Police Lieutenant Michael Link. And that's in the transcript from May 21st. Prior to the testimony, Ms. McCabe had never disclosed publicly or in any report or witness interview, even when asked directly about her meetings and conversations in the days and weeks following January 29th, 2022, that she visited the house of one of the responding police officers to 34 Fairview Road. So all the way up until um, her testimony, she had never disclosed this. But she brought it up during her direct examination. So that would be wild that all of a sudden she would just think to bring that up. Ms. McCabe, who is friendly with Mike Link, that's a quote, and knew of him growing up, testified that she could have been at Lieutenant Lank's house for an hour. After initially denying having entered Lieutenant Lank's house during the hour that she was present, she then remarked how she might have ran into the bathroom. So she lied or changed her story multiple times. When asked why she had never testified to this indictment, when asked why she never testified to this incident before, Ms. McCabe responded, "I guess I never thought much of it." The only time Ms. McCabe claimed to have discussed this meeting with anyone related to the case was at the DA's office with Mr. Lawley, Ms. McLaughlin, Steve Nelson, and Trooper Brian Tully. Brian Tully was there too. Ms. McCabe confirmed that at that meeting with the prosecution, she was specifically asked about her meeting at Lieutenant Lank's home, something which she had never revealed and about which she had never previously been questioned. So that's the first time that she was questioned about it was in the prosecution's office preparing for trial with Adam Lally, Laura McLaughlin, Steve Nelson, who was I think he was the witness advocate or something, and Trooper Tully, who obviously was investigating the case. So interesting that was the first time she had ever been questioned about that. At trial, she saved this information for cross examination. After questioning Ms. McCabe about a different topic, Attorney Jackson asked Ms. McCabe, did anything significant happen on January 30th in connection with this case? Any meetings, any get togethers, anything that you can think of? Ms. McCabe responded, I went to the O'Keefe's house. Attorney Jackson followed up, other than that, anything else? In response to this open-ended question, without any indication from Alan Jackson or Attorney Jackson regarding the answer he was seeking, Ms. McCabe volunteered this thorough answer. On the way home, Carrie Roberts' daughter is a good friend with Michael Lank, so we dropped her off at Michael Lank's house, and Mike's wife came out of the house. Him and Carrie are friends, and she, jumped in the car and was consoling Carrie and asks how the O'Keefes were doing. And, we talked to her. So that's Jen McCabe getting in front of impeachment material. This extremely detailed and comprehensive explanation as an answer to Attorney Jackson's open ended question, accompanied by Ms. McCabe's testimony that she had been asked about this meeting by Mr. Lawley at the DA's office, leads to the inescapable inference that Ms. McCabe was prepared for this impeachment question in advance of trial. That was only possible because, in compliance with this court's impeachment evidence reciprocal discovery order, the defense had turned over location data obtained from Miss McCabe's cell phone to the prosecution. So that was um, what got her, the fact that her phone tagged her at Michael Lank's house. This location data showed that Ms. McCabe was indeed present at Lieutenant Lank's personal home for approximately 45 minutes on January 30th, 2022. Although the Commonwealth did not elicit the information during its direct examination, Ms. McCabe had clearly been prepared for the question on cross examination as a result of the defense production of impeachment evidence. Another example occurred at trial on May 28, 2024, when PF, that's the pseudonym used to protect the identity of the minor witnesses whose information has been impounded in the matter of PF, testified in a closed proceeding. PF is the name or the initials of John's nephew. His name was Patrick, is Patrick. So, PF stands for Patrick, and they had a different last name. So PF testified for the prosecution. PF, who was 11 years old at the time of Mr. O'Keefe's death and 13 years old at the time of his testimony, described his experiences with the defendant during a SANE interview on February 2022. So a SANE interview, um, I believe it has to do with minors and interviewing minors in the process of criminal investigations and things like that. I don't know too much about it, but So he had this interview on February 22nd. PF had testified about an incident with the defendant wherein she got really mad at him. PF described how one time I had like steak tips and I was just eating them slowly because they were hard to chew, and she got really mad at me for it because I wasn't like, cuz she thought I didn't like them and I was spoiled and stuff. During trial testimony on May 28th, 2024, PF was questioned by the prosecution about this same incident. Prior to that testimony, Attorney Yannetti expressed his concerns about this line of questioning at sidebar, stating that there was testimony in the grand jury about my client supposedly getting mad at PF for eating his steak too slowly. We provided a video of that incident to the prosecution, which belies that testimony. So it showed something completely opposite of what they were trying to portray. So, Attorney Yannetti was expressing his concern that PF's trial testimony would diverge from the grand jury testimony as a direct result of the defense production of pure impeachment material to the prosecution on May 6th, 2024. This is, of course, exactly what happened mere minutes later. PF was asked by the prosecution about instances where he was yelled at by the defendant. He recounted, "One time we got takeout food and I was taking a little while to eat it, and the defendant thought I didn't appreciate it, so she got mad at me." So he changed his details because the video proved that the situation that they were explaining was not accurate. So then they changed some details around to make it seem like it was a different incident, basically. So 2 weeks prior to his testimony at trial, the defense turned over a video depicting PF eating steak tips, interacting with Ms. Reed in a playful manner wherein she never gets mad, directly contradicting his same interview from February 2022. PF undoubtedly met with the prosecution in preparation for his testimony. This resulted in PF changing his story to claim that it was takeout food and not steak tips that he had been eating, so that he could now claim that the defense impeachment video does not depict the incident that he initially revealed. See what happened there? They totally lied or changed their story because they had evidence ahead of time to basically um, quash the thing that he said in his grand jury testimony. But the Commonwealth didn't allow him to do that. So this is therefore another example of the prosecution using impeachment evidence produced by the defense pre-trial to coach witnesses to change their testimony during trial. Their unfair use of impeachment evidence creates an undue burden upon the defendant and should not be permitted. The argument here is the production of statements by adverse witnesses is not subject by mandatory disclosure under Rule 14 and must be sought by motion. So, Mass Rule 14 outlines the classes of materials subject to automatic discovery or materials mandated by rule to be produced by the prosecution and defense without need for a motion before the court. Rule 14 requires the defendant, following the Commonwealth's production of automatic mandatory discovery, to produce relevant evidence which the defendant intends to offer at trial, including the names, addresses, dates of birth, and statements of those persons whom the defendant intends to call as witnesses at trial. Rule 14 allows for the defense and the Commonwealth, following production of discovery required by Rule 14, to move for discovery of other material and relevant evidence not required by subdivision A1. A distinct line has been drawn under Rule 14 between materials subject to automatic discovery and material discoverable only by motion. Automatic discovery does not extend to statements that the defense intends to use for purposes of cross examination. And that's coming from another case. They're quoting that from this, I think, Commonwealth versus Durham. Automatic discovery does not extend to statements that the defense intends to use for purposes of cross examination, for impeachment purposes. In a given matter, the prosecution and defense are only required to produce statements intended to be used at trial, which are attributable to their own witnesses, subject to Rule 14. Statements attributable to adverse witnesses, for example, statements attributable to a prosecution witness that the defense intends to introduce at trial, are not subject to Rule 14, but instead can be ordered produced by the court in response to a motion under Rule 14. A trial judge has broad discretion, meaning she has many reasons to not uh, approve or allow a motion for reciprocal discovery. She has broad discretion with respect to motions for production of non automatic discovery subject to Rule 14. A judge has discretion to deny a movant's motion for discretionary discovery materials when the movant fails to establish a threshold showing that the material he or she seeks is relevant. The policy for Rule 14 is based on the concept of reciprocity and has as its aim full pretrial disclosure of items normally within the range of discovery. Here, the Commonwealth's request for production of statements of individuals that they intend to call at trial was not information subject to the automatic disclosure requirement of Rule 14, as they were not statements of a witnesses intended to be called by the defense. I think that mm, was an error. I think she meant statements of a witness intended to be called by the defense. Thus, production of such statements was subject to the court's discretion based on a showing of the relevant nature of such evidence and the aims of fair disclosure for trial. The production of impeachment evidence prior to witness testimony has created unfair prejudice to the defense and has undermined Ms. Reed's right to confrontation. Rule 14 of the Massachusetts Rules of Criminal Procedure in the mechanism for sanctions in response to violations of discovery orders pursuant to automatic or discretionary production orders discussed in Rule 14. Sanctions may be imposed upon non-complying parties to remediate the violation in a way the court sees fit. Sanford describes the two tenets of sanctions under Rule 14. First, sanctions are remedial in nature. Second, sanctions should be tailored appropriately to cure any prejudice resulting from a party's noncompliance and to ensure a fair trial. The purpose of such sanctions must be remedial, not punitive. Similarly, when a sequestration order in place with respect to witnesses at trial is violated, the judge has discretion to remediate the violation, including to admit or exclude the testimony of witnesses who have violated the sequestration order. So let's say Jen McCabe admitted to watching the trial or something, and she watched portions of the trial and she admitted to that, that would violate why can't I say that right now? Sequestration orders. And she, part of that might be to, strike someone for testimony or whatnot, or not have her testify. Rule 14 of the Massachusetts Rules of Criminal Procedure give judges the discretion to alter or amend discovery orders as the interest of justice require. The defense's production of impeachment materials pursuant to the court's allowance of the Commonwealth's motion for reciprocal discovery clearly altered the trajectory of the Commonwealth witness testimony. Additionally, the defense believes that violations of the sequestration order occurred during the first trial. In addition to the inclusion of testimony not adduced at previous hearings, a message from one of the witnesses from the first trial demonstrates that at least one witness likely violated the sequestration order with the knowledge of this prosecution. On July 1st, 2024, prosecution witness Trooper Michael Proctor sent a text message to Assistant District Attorney Adam Lawley that stated, "Yeah, didn't watch asshole Jackson's closing for good reason. Like all of us, the anticipation and anxiety of verdict has us all on edge." That is a screenshot of, or in a screenshot of Proctor's text message to Lawley from July 1st, 2024. And that is subject to a protective order due to personal identifying information. Mr. Proctor's message suggests that his decision not to watch the proceedings on July 1st, 2024 was not out of effort to abide by the sequestration order, but was instead related nature of the defense closing argument itself. The message implies that Mr. Proctor, no longer Trooper, just Mr., has or had been following the trial online and simply skipped the defense closing argument because he does not like Attorney Jackson, which he made clear in his text messages with his buddies and or no, that was Ionetti that he didn't like, but now he doesn't like Jackson either. So now it's very clear how Proctor feels about all of Reed's attorneys, or at least Ionetti and Jackson. All right. So even absent this admission, the unique nature of the case, including pervasive media coverage and real-time streaming of the in-court proceedings during trial, creates opportunity and temptation for witnesses to watch the testimony of others in violation of the sequestration order. The risk of even inadvertent witness exposure to trial testimony such that witnesses would alter their testimony or anticipate otherwise unexpected impeachment material would be cured by the court modifying the reciprocal discovery order to exclude defense impeachment material. Apparent violations of the sequestration order coupled with the defense production of impeachment material, allowed prosecution witnesses to either preempt cross-examination topics by first addressing damaging information during direct examination in an effort to take the sting out of the cross-examination, or to have polished answers prepared when asked about the same topics for the first time during cross-examination. The inability for the witnesses that will be called in this matter have already testified at least once, and sometimes sometimes three or more times, under oath, either during the state grand jury proceedings, federal grand jury proceedings, or during the first trial. So some of these people have been testifying, well, many times. The only witnesses who appear to have not testified to this point would be a small number of experts who may yet be subject to voir dire. To the extent the defense sought to maintain any element of surprise, and the defense would suggest that Ms. Reed has been far more forthcoming than most criminal defendants prior to her first trial, much of that surprise has already been foiled. What the defense requests now that the court not order the defense to produce impeachment materials will aid in balancing the need for reciprocal disclosure contemplated by Rule 14 with the need for remedial discovery measures to protect the defendant's right to a fair retrial. The preemption of impeachment materials by prosecution witnesses is unfair because the record clearly demonstrates that the witnesses discussed above, including PF, Lieutenant Lang, Jennifer McCabe, and Mr. Proctor, either prepared for impeachment evidence prior to testifying and changed their testimony from earlier occasions, or likely violated the sequestration order of this court. The defense is requesting that the court modify the order for reciprocal discovery only to the extent necessary to prevent prosecution witnesses from using pretrial production of impeachment evidence to tailor their responses as the interests of justice require. Whether the aforementioned violations are characterized as violations of the discovery order or the sequestration order, the court is empowered to impose sanctions ahead of Ms. Reed's retrial to remediate the threat of injustice under either scheme. Finally, the defense is not requesting the court for permission to engage in trial by ambush nor engage in theatrics. So it is not trial by ambush or theatrics by being able to impeach someone. That is the point of cross examination. The effectiveness of cross examination often depends on being able to surprise a witness, particularly an accusing witness, with evidence that contradicts or is inconsistent with his trial testimony. A second trial following state and federal grand juries and an extensive first trial can hardly be called trial by ambush. That's a great point because the Commonwealth already has their testimony from any state or federal grand juries that they've been a part of and trial one. So anything that the defense wants to use within all those transcripts, that's fair game for them to use. And they don't need to say, hey, Commonwealth, by the way, we're going to use this line from, the trial one where Jennifer McCabe said this to impeach her. Like, it doesn't work that way. You're not going to tell them this is how we're going to impeach our or your witnesses. That's not how it works. You're supposed to be able to surprise them. It's not trial by ambush because Commonwealth has the info too. They have all the evidence as well. So to the contrary, the amendments requested by the defense will permit the jury to assess for themselves the reliability of a witness's memory or whether an accuser is truthful. The defense is simply requesting a fair and equal opportunity for each party to confront adverse witnesses with impeachment evidence without each witness being able to review such material and alter their responses accordingly. For the above reasons, Ms. Reed respectfully requests that this honorable court allows this motion. And that's signed by Alan and Elizabeth. I want to say Elizabeth Little wrote that, but I'm not sure. That was a good one. I thought whoever it was that laid that out, I think laid out some good arguments as to why they should not be able to, or why they should have to turn that over. And it's not required anyways. But as the Commonwealth tends to do, they object to that as well. So they're opposing the defense's motion to reconsider. So now comes the Commonwealth and respectfully requests that this honorable court, what does that say? Deny the defendant's motion to reconsider this court's allowance of the Commonwealth's March 21st, 2024 motion for reciprocal discovery. The Commonwealth's motion, which was renewed on February 11th, 2025, and this court's previous order are in conformity of Rule 14 and serve the interests of fairness. Well, if he's being truthful at all, then he would be truthful in that it is not required, but then he needs to show good reason why he needs to receive it, why it's relevant. At its inception, Rule 14, as then numbered, provided that a court in its discretion could order reciprocal discovery to the prosecution. This provision derived from then recent holdings of the United States Supreme Court relative to the rights of the prosecution to discover a defendant's case. The very integrity of the judicial system and public confidence in the system depend on a full disclosure of the facts falling within the framework of the long-standing rules of evidence. To ensure that justice is done, it is imperative to the function of the judicial system that compulsory process be available to produce evidence needed by either the prosecution or the defense. The prosecution is empowered to call upon the power of the court to compel production of evidence which will facilitate full disclosure of all In 2004, revisions to Rule 14 expanded the defense's obligations by making reciprocal discovery mandatory, not discretionary. So, Rule 14, when the prosecution certifies that it has disclosed and made available the discoverable items within their custody and control, the prosecution is then entitled to automatic reciprocal discovery of specified categories of defense evidence. Any difference between these obligations on the defense and the prosecution result from asymmetrical constitutional requirements. The defense's obligation is limited to evidence it intends to introduce at trial, whereas the prosecution has a broader obligation. The second difference is merely in timing of disclosure as the defense. I feel like this is like confusing on purpose. He's just throwing in a whole bunch of, well, this is what the rules say, just to kind of confuse and not exactly, paint an accurate picture of what the defense is doing. So the second difference is merely in timing of disclosure, as the defense need not produce any material until after the prosecution has disclosed its evidence to the defense. Under Rule 14, automatic reciprocal discovery commences only after the Commonwealth has delivered all discovery required pursuant to the automatic discovery provisions of A1A. After that point, and by a date either agreed upon by the parties or as here ordered by the court, the defense is obligated to provide the Commonwealth with discovery of the names, addresses, dates of birth, and statements. Yes, that's what they said. They know that that is what is required and they will hand that over. They don't have to hand over impeachment material. The defendant objects to providing Commonwealth with any impeachment evidence prior to the witnesses testifying on direct examination. In Commonwealth versus Reynolds, the court found that discovery of impeachment evidence or statements of the Commonwealth's witnesses that a defendant intends to use in cross examination must be pursued by motion, as they were on March 21st and February 11th. Notably, the defendant did not object to the Commonwealth's March 21st motion. Rather, during the defendant's first trial, the defense attempted to ambush the Commonwealth with witnesses with impeachment evidence that was never produced. That's not true. In violation of the court's order, and when something comes up in trial and you get discovery sent to you that basically impeaches that witness, you should be able to introduce it. As in when Katie McLaughlin, the firefighter, said, "Oh, Caitlin Albert, I went to school with a Caitlin Albert. Like, I don't know who that is, even though I'm pictured with her all throughout my teens and 20s in many social settings." So, that kind of impeachment material, they can't produce that prior to trial, but if they receive it during trial, they should be able to introduce that. And Judge Bev said no. In violation of this court's order, the defendant selectively produced reciprocal discovery throughout the first trial, and most notably, what the defendant attempted to introduce as impeachment evidence were not inconsistent statements of the Commonwealth's witnesses, but rather unauthenticated photographs, social media posts, or exhibits that the defendant was and is required to produce prior to trial. Okay, but it's okay for Colin Albert and Caitlin Albert to enter uh, screenshots of text messages that clearly look altered and they haven't been verified or authenticated. That's okay? Wow, this court is so, I mean, everything is so backwards here. Ordered discovery is permitted by the rule, which cannot, as the defendant seeks to do, be read in isolation. Under the rules, the court has authorization to order the defendant to disclose any material and relevant evidence discoverable under subdivision A2, which the defendant intends to use at trial. Evidence discoverable under Rule 14 includes any materials and relevant evidence, documents, or statements of persons within the possession, custody, or control of the adversary. Nothing in Rule 14 limits the word persons to include only witnesses whom the disclosing party intends to call at trial during the presentation of its case in chief. Such a limitation would be contrary to the fact that persons characterized here are prospective witnesses belong neither to the Commonwealth nor to the defense. They are not partisans and should be available to both parties in the preparation of their cases. The same can be said for their statements, a point made forcefully in Reynolds, where a conceptually similar but not contested pretrial discovery order was enforced, the following terms allowing the defendant to withhold the ordered evidence in the form of written or recorded statements against a witness who is certain to be called to testify would undermine the discovery rules and allow attorneys to return to trial by ambush. Theatrics do not accord with our discovery process. Okay, but they just told you this is not theatrical and this is not trial by ambush. You have the information. We're just not pointing to that information to make it easy for you. You already have the impeachment evidence. So this is bogus. And I have a feeling that Judge Crooked Bev is going to she's going to allow it again. I hate her so much. All right, so the reporter's notes to Rule 14 do not suggest that statements for impeachment purposes should not be discovered by the Commonwealth. The notes merely make clear that any such discovery is not automatic, but rather requires a motion before the court. Yeah, but they just explained in their motion that you have to prove that there's some relevance as to why they need this. They need to um, prove why they should turn it over, which they have not done. Such motion was filed and allowed in March 2024. As a result, the defense may be required to make strategic choices in the trial process, but that consideration provides no basis to invalidate the order nor cause the court to reconsider it. In the end, broad discovery makes for a fair trial and enhances the likelihood that the truth will come out. Really? Does Hank really give a crap about the truth? If he did, he wouldn't be doing this. He wouldn't be filing all these ridiculous motions to cut Karen's defense off at the knees and allow her to, disallow the ARCA experts and try this BS that he's trying with trying to get Jackson in trouble for some reason. So it's ridiculous what they're doing. And for him to say this is all in fairness. This is all for having the truth come out. Get out of here. Get bent is what I would like to say to to Hank. He doesn't care about the truth. There is no question that effective cross-examination is an important safeguard of liberty and a valuable tool for testing the reliability of evidence, thereby ensuring a truthful verdict. We also have no disagreement with the view that, as a tactical matter, surprise can be an important element of effective cross-examination because they want to be able to use it too, I'm sure. But neither of the propositions is affected by the order to a degree where it can be held that the defendant's constitutional right to confront witnesses against would be violated. The right to confront and cross-examine a witness is not absolute and may, in appropriate cases, bow to accommodate other legitimate interests in the criminal trial process. The trial process seeks to ascertain the truth. Our conclusion recognizes that the truth is most likely to emerge when each side seeks to take the other by reason rather than by surprise. The defendant cannot shield herself from discovery obligations by citing defense trial strategy. The Commonwealth is entitled to a fair trial and simply has sought what every criminal defendant in the Commonwealth of Massachusetts is obligated to produce, and that is signed by Hanky Breenan and Adam Lally and Laura McLaughlin. And that is what I have so far, or what we have in conclusion for the reciprocal discovery motions. We still have a couple more videos to get through of these many, many motions that have come out, and we're getting through them. So thank you guys for watching. Let me know what you think. Do you think that they should be forced to turn over impeachment discovery? Do you think that this is a winning argument? I personally don't. I don't think Bev is going to buy it, but um, we'll see. They haven't had the opportunity to argue it yet because Bev shut their hearing down. So we will hear Tuesday. They are going to be reconvening, and whatever bombshell stuff is going to be happening at the hearing, we'll find out. But also, hopefully, they get to argue some more motion, all of these other motions. So we'll get some resolution in the near future. Although Judge Bev very, very, very rarely actually rules from the bench. So we probably won't find out the day of the hearing for any of these motions. But let me know what you guys think, and I will see you guys in the next one. Take care. Bye now.